Thank you, Mr. Longo and your colleagues from ASIC. Mr. Longo, would you agree that for buyer beware to work, buyers need to have access to all available information?
The general principle, buyer beware, availability and also asking. Yeah. So the information clearly, as your question proposes, information needs to be made available, but the classic application of the buyer beware principle is the buyer also has to ask questions and take an active interest in ensuring they're properly informed before doing things.
Thank you. Before getting to my core questions, I need to reference information contained in the redacted internal ASIC chronologies that were provided to the Senate. I know some of the details have been laboured over, yet I need to reiterate them for the purpose of these questions. So firstly, 4 points. In May 2015, ASIC concluded internally that Sterling had likely provided financial services while unlicensed. Secondly, Sterling had likely not provided adequate documentation to retail investors. Thirdly, Sterling had likely engaged in misleading and deceptive conduct. And fourthly, Sterling may have breached the requirement to not engage in conduct liable to mislead the public. Are these details correct or substantially correct?
Mr. Longo, do you want me to take that?
I was just talking to my general counsel. Go for it, Reece.
So yes, that's a reference to an early complaint we received, the first one we received, which was from FOS. At that time, it appeared to be one breach without any prior or later concerns. It was about a 3-year-old breach already at the time. And in the circumstances with a myriad of other complaints and referrals we had, we formed the view that no further action was needed at that time.
So they're correct. Thank you. So despite these conclusions, ASIC elected to not pursue an investigation at that time due to the age of the conduct and the other workloads, etc. So continuing to check my understanding, in June 2015, an ASIC staff member raised fresh concerns about Sterling providing unlicensed financial advice or that it may be engaged in misleading or deceptive conduct. And secondly, and the last fact I want to check is that in September 2016, ASIC received a complaint that a Sterling victim had concerns about misleading and deceptive conduct and was unable to get information about what had happened to their investment and could not withdraw their investment as they had been led to understand that they could. Are those 2 points correct?
That is a slight simplification, but yes, basically they are the second and third complaints that we received. They're referred to in our submission as well, Senator.
Yeah, thank you. So,
Senator, can I just ask, the line of questioning is rather, these points have been dealt with comprehensively in our written material, and I would respectfully ask that the approach, the rather simplistic approach that I'm hearing this afternoon, the committee can inspect a supplementary written submission to comprehensively deal with the inferences it appears you wish to draw. But these matters have all been dealt with comprehensively in our written submissions, questions on notice, and do not change my earlier evidence that I believe ASIC behaved reasonably at all material times. I do respect the line of questioning, but I would ask the committee to expect a supplementary submission to confirm the position we've taken on these earlier reports that I believe were properly handled at the time. Thank you.
Thank you for repeating that conclusion from yours. In January 2017, ASIC assumed that Sterling's conduct fell within the small-scale offer exception for professional investors, despite a track record of complaints relating to retail investors. ASIC suspected that a new and ongoing managed investment scheme was in operation. A managed investment scheme was in operation. And despite all of this, ASIC recommended that no further action be taken in relation to Sterling. Did ASIC commence any type of investigation before concluding no further action was required? And if so, specifically, what investigation steps?
Through the chair, could I ask Senator Roberts to ask a question, please?
Yes, I just did. Did ASIC commence any
respect,
type of
there's
investigation?
quite a narrative that preceded your question, which makes it very hard to answer the question fairly, given the premises upon which it's based, which that are very hard to follow.
Certainly, Mr. Longo. Certainly, Mr. Longo. I'd be happy to do that. Yeah, this is what I asked.
Senator Roberts, if you can, just to make it as easy as possible for us all to follow, if you can really just go through the introductory points one by one that set up your question, just so we can understand the preamble to give the context to our witnesses from ASIC. So sure. Over to you.
Sure. What I'll do, Chair, is I'll address Mr. Longo's request and ask the question, and then go through the introductory comments. The question is, did ASIC commence any type of investigation before concluding that no further action was required? And if so, specifically, what investigation steps? Now, some of the earlier comments
were... At what point in time are you asking me the question that we took no action? At what point in time are we talking about?
So I think Mr. Longo, Senator Roberts, is now going to go through the preamble and give you that context before you, so you can answer the question. So in particular, the timing we're talking about, Senator Roberts, the actual step.
Thank you, Chair. Thank you for understanding. In January 2017, ASIC assumed that Sterling's conduct fell within the small-scale offer exception for professional investors, despite a track record of complaints relating to retail investors.
Now, Senator Roberts, if I can just hold you there. So there's a point you've made there, and it's based on certain premises. Yeah. So perhaps if we can ask ASIC just to respond to that particular point first.
Yeah, the bit of that. The idea of there's an assumption that would apparently be made in January 2017. Reece, can you comment on the assumption that apparently? Can you follow what's going on here?
So the Senator is referring to the first three complaints and the redacted chronology that was tabled by Senator Hume earlier. So those three early complaints, the one from the Financial Ombudsman Scheme, the second from an internal staff member, and the third in late 2016, early 2017, they were all assessed by our intake team, who receives all reports of misconduct, breach reports, and so on. We have a large number each year, 10,000 or so reports of misconduct, 4,000 or so breach reports. So they're all assessed. I wouldn't describe that as an investigation, Senator. It is an assessment. There is policies and procedures that the assessment team follows. They look at the evidence, they look at the number of people who appear to be affected, the amount of money that appears to be involved, the age of the conduct, the likelihood as to whether it's systemic or not, and they have to make a judgment about, based on the information that we've been given by the complainant or by in the breach report, whether further action should be taken. They necessarily have to be quick judgments to get through that kind of a volume. And yes, you're referring to the views that that assessment team formed at the time as to whether it likely fitted into the small-scale exemption and so on. So yes, those assessments were made at the time based on the information in those three early complaints.
Okay, thank you. So what we're looking at here is trying to get an understanding, because I work for the people of this country and I serve them. They pay my salary, they elected me, and I have to serve them. And I think that's what all members of the public service have to do as well, including members of ASIC. So what we need to understand is, what does ASIC see as the breaches? Were there breaches of law? Were there breaches of good faith? What's the core issue? Is it capacity of ASIC? Is it capability of ASIC? Is it structural? Is it a legislative or parliamentary fix? What's the intent going on here? So that's overall where I'm heading, because I can either help you or undermine you.
Yep, Senator Roberts, there's a lot there.
No, I'm just explaining. So let me continue.
I understand.
Just to go back to, though, your questions about the report of misconduct that came in 2016 to 2017. I just think it's important, and we've put this on as an answer and a question on notice. That report of misconduct was an investor who appeared to have purchased shares in a company called Sterling Residential Syndicate Australia Pty Limited. So it related to a different type of investment. I just thought it would be helpful for you to be aware of that, because it's a different type of investment from the Sterling Income Trust that we're talking about. It's same broad group, but that was the context of that one.
So Commissioner Armour, if I can, sorry, with your indulgence, Senator Roberts, Commissioner Armour, can I just ask you, so that complaint which was made, it did not have an attached or stapled residential tenancy, is that correct?
Look, I'm taking my answer from our answer to the question on notice which was back in 2019-20. So we're happy to take on notice if there was anything stapled to do that. And
yeah, could you perhaps, and I'm reading the same, I've got it here with me too.
Yeah. Yep.
So I would be interested to know in relation to it, and there were three, as you know, in that question on notice which was provided, the three prior issues which were raised. I think it would be helpful if ASIC could provide as much information, additional information with respect to those three issues as possible, because I would certainly be interested to know whether or not any of them had the hallmarks of the attached residential tenancy, as well as the purchase of shares.
Senator, I can give you that assurance now that those three matters are outside what this inquiry is actually looking at. I've said repeatedly and tried to act in good faith with this inquiry that the March meeting with Consumer Affairs in 2017 was really a significant meeting, because that's when, without wishing to oversimplify, some of the dots started getting joined up. And that's when, as I think the evidence has shown to the inquiry, that ASIC's interest in this matter really started. Okay, there's been a lot of evidence and back and forth about whether we should have done more things more quickly or whatever. But to my mind, the way I'm looking at it, I wasn't around at the time, I'm trying to be objective and trying to be professional with the inquiry. To my mind, around March 2017 is a realistic moment to say, well, there was that meeting with Consumer Affairs. We started talking with Consumer Affairs in a way that actually started looking at the issues that are the subject of this inquiry, and the rest is history. Pre-March 2017.
So Chair Longo, you've been very consistent, but in terms of your testimony, that these three prior complaints that were the subject of the answer to this question on notice, Commissioner Armour refers to, from your perspective, you're quite adamant, quite clear that these matters were totally disconnected from the matters which are the subject of this inquiry. Is that correct?
That's correct. But with respect, I do appreciate the people wanting to understand, well, why not? There were these three ROMs. Surely, that must have got you thinking. And I respect that, how can I put it, curiosity. And so we will file a concern, absolutely. I mean, I was concerned. I mean, when all this came to light, Senator Roberts, I put with the help of my team, a lot of time into really trying to understand what happened. And so this is my view. It's my duty to give you my view. And so I think from March 2017, I've said to the team, to my mind, that's when the dots started getting joined. Now, but absolutely happy to come back to the committee. There's been a few quans submissions dealing with this point. It might be helpful to the committee to put it all in one place. And we'll write, and hopefully that'll sort of clear the air on it. But as I've said from the beginning, we'll do that as quickly as we can. And if there are additional questions from the inquiry saying, well, we still, have some queries, we'll deal with those too, as best we can.
Excellent.
Okay,
thank you, Chair Longo. Senator
thank
Roberts,
you very much.
Paul.
Can ASIC explain to this committee how it interprets the phrase reason to suspect as detailed in Section 13 of the ASIC Act?
I'm looking forward to this answer, Chair Longo.
Well, there's a lot of jurisprudence on that question. The we interpret that phrase in a conservative manner to if we have reason to suspect, if there are facts or circumstances that we think could point to a contravention, then we may, but are not required, to commence an investigation. So I think the short answer, I think the practical answer to your question, just reflecting on it, is it's a pretty low bar. I don't think I don't think anyone's going to tell you that a reason to suspect is a very high bar. It's a very low bar, and so it should be, because you want people like ASIC being able to investigate things without having to jump over a high bar, because that wouldn't be in the public interest. The critical question, Senator Roberts, and I hope you'll forgive me for saying this because I've been saying it repeatedly through most of my professional life, is that we can't investigate everything. And so what tends to happen is a lot of judgment and assessments and analysis goes into, of all the matters that come to our attention, the really hard part of our job on the enforcement side is choosing which ones to investigate, resource, have Section 19 examinations, issue document notices, and which ones not to. And so I know in this inquiry there's been a lot of questions about, well, what's going on here? Your investigation didn't start, I think, till May 2018. Why didn't it start sooner? So I'm not here to tell you that there was a big legal impediment. It was the situation unfolded. We made judgments based on what we knew at the time. We commenced an investigation when we did, and we took the steps we took. But it is a low bar. The short answer to your question is it's a low bar, and we have to make decisions about which things to investigate and which things not to.
Thank you. Are there any internal criteria or operational procedures or guidance as to how Section 13 powers are to be exercised by ASIC and
yes,
when?
There are. Yes, there are.
Could we get them as a question on notice, please?
This question's come up before. I'm looking at my general counsel. We have...
that was me. I did ask that question before.
That's fine.
So, and I think, yes, we were going to get that provided to us.
Yeah, well, it's not an uncommon question. We'll certainly share with the committee what we can. There may be, when I say what we can, there may be some material we would be happily share with the committee on an in confidence basis. Because you will appreciate that some of that internal material, it wouldn't be in the public interest for the whole community to know about it, but we'll certainly provide you with what we can, and where we think there's a sensitivity, we will ask the committee to accept that material in confidence.
Thank you, Mr. Longo. Next, who and what level of seniority within ASIC is able to make a determination on whether ASIC can trigger Section 13 powers?
I was about to say relatively junior, but there's a system of delegation of powers that we use so that the commission itself isn't involved in every decision to commence an investigation. So because of the range of matters that come to our attention, we have a process and a system for figuring out which ones to investigate. But there's a governance structure, a committee structure within ASIC that makes those decisions. I suppose we could include a description of that in the...
You're reading my mind now.
Yeah.
Thank you very much. That's exactly where I was going.
I have to tell you, Senator Roberts, it's a very risky business thinking I can read someone's mind.
I thought you were referring to my mind.
Well, I can't just generalise that. I can't read anyone's mind.
Yeah, I have difficulty too reading mind. That's why I ask short questions generally. Is there a threshold of evidence that a complaint to ASIC must meet before Section 13 powers can be exercised? I think that's part of really the earlier question. I think you undertook to give us that.
Yeah, I think that there's been a lot of confusion about this over the years. Just stepping back, the ASIC gets matters, issues, concerns brought to its attention by a whole range of sources, as you can imagine. Like we might learn about something, reading about it in the newspaper, and say, well, we need to get on that. What you're focusing on, which is really the sort of a big part of resources, is those thousands of complaints that Reece referred to earlier. We have a very systematic, I would like to say, sophisticated approach to figuring out what to do with each and one of those matters. And we have internal benchmarks to make sure they get prompt attention. And so a lot of them are actually resolved by getting other agencies involved. Sometimes we're just helping people with a query that we can't take any further. So long story short, an assessment is made. Now, some of those matters will become investigations, but that depends on a whole range of circumstances that I think Reece touched on quite a few of them. But the general principle is it's not every matter that could lead to an actionable contravention that we will investigate.
Senator Roberts, we're running about 30 minutes over time. So do you have many more questions?
I think they're all fairly short, Chair.
Okay.
Given the track record of complaints...
I have a couple more too, Chair. My apologies.
Given the track record of complaints, how was this for Sterling, how was this threshold not specifically met?
I'm not sure. I think we really are at cross purposes now. I think as to the first three, I just don't think they led us anywhere close to what the inquiry is looking at now. From March 2017, as I've said earlier, we had the interaction with the Consumer Affairs, and that triggered what we did and didn't do. Now, clearly, we've had several days of hearings now, and we're trying to work through what we did do, what we didn't do, and why. So I'm not sure I can really add much more to that story.
Okay. Thank you,
the formal
Mr.
investigation started early 2018.
In the context of Sterling First, it took ASIC 1 year and 2 months from March 2017 to May 2018 to exercise its Section 13 powers and commence a formal investigation only after receiving a complaint from a government department, as I understand it, the Western Australian. Wouldn't a reasonable person expect that ASIC would have reason to suspect, after receiving a complaint crammed with concerns from a state government department in much less than a year?
Well, I don't accept the premises of the way you've put those questions. As we've gone through in written submissions and in evidence, we responded to the material. I mean, after all, Consumer Affairs were aware of this matter for several years. I mean, they were aware of the issues with the tenants and then made the connection and came and spoke to us. And we started looking at it, and we've taken the steps we've taken. Senator, I'm not trying to make excuses. I'm just trying to sort of work through what we did and didn't do based on what we knew at the time. Now, I respect the fact that some people might say, well, you should have started your investigation, the moment you left the meeting room with the Consumer Affairs in March 2017. Well, with all due respect, I think that's entirely unrealistic. And that was never going to happen. So I think we've tried to work through why that's the case. But I think a commencement of an investigation early 2018 and the particular circumstances of this matter, I think is a reasonable timeline. Remembering we don't have any visibility into these investments. We're not there when the investors sign the leases and put their money into a managed investment scheme. We're not there when the product disclosure statements are given to these investors. And indeed, right up until the time we commenced the investigation, the investors weren't even complaining to us. And then by the middle of 2018, a lot of investors seemed relatively happy with what they were getting. And so these situations, as I've tried to explain in earlier evidence, really require a lot of judgment as to when to intervene and how much do you need to have before you intervene. Because it's not uncommon for investors in managed investment schemes to say, well, why did you intervene so quickly? That was all going really well. It's your fault, ASIC, that this scheme's collapsed. Alternatively, it's your fault, ASIC, that you didn't come in here sooner and stop this scheme. And so I think I've really given this a lot of thought, Senator Roberts, and I really think this inquiry is an opportunity to sort of revisit. I'm not here to make excuses. I really want to reassure the inquiry about that. We have a number of managing scheme matters that we're working on right now that could lead to court action, and there are others that already have. The Sterling situation is tragic, but it is part of a much bigger picture. And with all due respect, I think the inquiry is really getting, these are big issues. And so, we'll do whatever we can to be helpful. But as far as this particular matter is concerned, I think ASIC acted reasonably. And we did, I think, actually reasonably quickly with what we had. And could we have moved more quickly? Probably. Should we have issued a media release more energetically? Probably. But the investigation, the time it took, the issues we've had to deal with, I think we've handled that reasonably. But I do respect other views of frustration on this. But we'll do whatever we can to provide additional information to the inquiry to better understand the issues. But as I've said in earlier evidence, this is going to happen again and again and again.
I accept that this is a complex situation. There are many levels at which it needs to be investigated, and I think that's happening. Victims, as I understand it, thought they were paying rent in advance, some of the victims.
Yes.
Victims did not make a decision to invest in a managed investment scheme. I think that's clear as well. Victims did not make a decision to invest in a managed. Some of them.
I'm not sure that's right. I'm sorry. I've got to, with due respect, I've got to disagree with you about that. I don't know what investors were thinking at the time. What happened here, and I've looked at the documents personally, they signed a residential tenancy document, and they also signed documents to invest in an income flow that would pay for the rent. They signed documents signing over the income from that managed investment, so it went into a bank account to pay for the rent. Now, I do acknowledge that for many investors, if not all of them, that they didn't fully appreciate what they were doing or the risks, but there's no doubt they signed documents, because otherwise this couldn't have gone ahead.
I'm not arguing that, but does ASIC not see that some of the victims did not know that it was a managed investment scheme?
I can't speak for their state of knowledge.
Is that a possibility? Because you've made it quite clear, and I don't expect you to read minds, but where is the deficiency in Sterling? Is it in ASIC's exercising of powers, ASIC's analysis, ASIC's capability? Yeah. Is it the law? Is it the intent of the people who were putting out this scheme?
The way I've taken your question, Senator, it's a bit like talking about crypto. I mean, or why people buy stock exchange shares, or why they put money into superannuation. I don't know. I don't know. When someone puts their money into a managed investment scheme or buys shares on the Australian Stock Exchange, that they are motivated by whatever is going on. But I'm not here to. I can't tell you what they were thinking at the time, because at the time they had the benefit of marketing material saying that there was an innovative product, that this would enable them to have a higher standard of living, that they could sell their home and put the proceeds into an investment, into something that would generate income to pay for rent. Now, I know there's sort of a feeling, well, we can't use, they're not investors. But where did the money come from to pay for the rent? It wasn't coming from their bank account. It was coming from this other place where they put their money, I'll call it an investment, and that income went into paying the rent, the so-called stapling. Now, I'm the first to concede this is a complicated arrangement and risky. But I, with all due respect to the investors, I can't speak on their behalf as to what they were thinking or at the time.
But Senator, the responsibility for the success or otherwise of the scheme rests with the people who promoting and develop the scheme. That is the model that we're operating in, where a degree of latitude is provided to firms and individuals to develop schemes and to attempt to attract investors into those schemes, and they own, if you like, the success or otherwise. There's a framework they need to operate in, but it is really the responsibility of the promoters of the scheme.
And then we have regulators to oversee the promoter's intent.
But only the regulators work in the framework. We oversee the promoter's conduct. So as we talked about previously, a lot of what we do ends up being retrospective, because that's how we've set the system up. When things go wrong, we take action, but we don't have the merit powers that would substitute, say, my judgment for an investor's judgment at the start of the investment.
So let's get to my final question then. With a with a statement first that this is a complex situation. Mr. Longo has acknowledged that. Regulations are a double-edged sword, is something I'm saying, because dishonest people can quite often hide behind regulations, especially complex regulations. What is the core issue in your view, Mr. Longo? Is it capacity of ASIC? Is it capability? Is it structural? Is it legislative? Is it the intent of the promoters of the investment scheme? What is the core issue here, or what are the core issues here, and what's needed to prevent it happening again?
That's a really generous question.
Yeah,
I think we live in a free country. You know, we're a democracy, and we encourage people to make their own decisions about what they do with their lives and their money and everything. And I think one of the really big issues for all of us here is that we know from our life experience that good people, very often highly educated people, do silly things with their money. And they put their money into things they shouldn't put their money into. And there are lots of examples over the years. So one big policy question for us all is, should we have a law that makes it harder for people to put their money into investments that a group of people like us in an inquiry like this would say, gee, that's a bad idea, you know, that's really risky, you know, you really shouldn't do that without, I don't know, getting advice, or, you know, whatever the rules are. So I think that's one big question for the inquiry, because this system, as I think Commissioner Armour was just reminding us, is that it's pretty liberal. You know, it basically says if you follow fairly, I'd actually describe it as liberal, managed investment scheme criteria, responsible entity criteria under the Corporations Act, then a whole range of investment opportunities, inverted commas, are opened up to ordinary people. And so I think to me, the heart of it is, do we want to change the law to say, you know what, we're going to make it much harder for certain people, we'll call them vulnerable consumers or retail investors, putting their money into something like this without a proper rating or proper counselling or access to proper advice, you know, whatever the safeguards are. So I think that's a legitimate issue. That's a legitimate question.
I've got a follow-up question to this, Chair, when we're able. Thank you.
Yeah. And then there's the role of the regulator, and there's big issues there too, because we know regulation can be costly, it can be inefficient, and also it can give people a false sense of security. So one of the issues here, I think, is that people say, oh, this managed investment scheme's been registered with ASIC and responsible entity has a license, then it sort of has this veneer of like an imprimatur, if you like, from the regulator, and nothing could be farther from the truth, right? Our role is essentially a licensing administrative role. There's some substance underneath it. I'm not saying it's totally administrative, but the policy objective is to encourage investment, to encourage risk taking, and then as Commissioner Armour reminded us, what happens after that is retrospective. It's reactive. You know, we don't spend a lot of time looking at whether the business models work or not, or whether the PDSs are accurate or not. So that's another big question for the inquiry. You know, do we want to change that? So look, I could go on, but I thought I'd just pick a couple of those. I don't know whether Commissioner Armour or Rees, I've missed something fundamental. It's obviously a very generous question from Senator Roberts. Kathy or Rees, you want to add to that?
It's a very fundamental question, isn't it? Because it's quite apparent from reading many of the submissions that there is a disconnect between potentially what investors anticipate, or some investors anticipate, and what the framework is. And so it's a very fundamental question, I think.
Look, only thing I'd add, Senator, we've mentioned this in our submission. There have been a number of inquiries over the years suggesting improvements to the managed investment scheme regime around how insolvent schemes and non-viable schemes are managed. Indeed, this committee has made recommendations in the past. I think there is some fertile food for thought in that area.
I'd just like to add, Chair, that Mr. Longo made the statement that we live in a free country. Thank you very much, Chair. Thank you, Mr. Longo, and your colleagues at ASIC.
Okay.